Good evening, everybody. Welcome to the Baku American Center Facebook page and the U.S. Embassy Facebook page as well. We're delighted you could join us. We beg your pardon for the technical difficulties that had us starting a little later than we'd wanted to this evening. But as we know, these things happen. In any case, we are thrilled to be offering the third installment of our ongoing series, the U.S. legal system, offered by Fulbright Scholar and law professor Judith Ogden. Professor Ogden, a professor at Clayton State University in Atlanta, outside of Atlanta, Georgia, is going to offer again her third and final installment in the series this evening, talking about a subject that she is particularly well versed in, which is arbitration and mediation and other alternative dispute resolution mechanisms. Professor Ogden has made this particular area her stock and trade through, in the recent period, offering these services to a variety of international and domestic clients, and recently has been named to the Western Carolina University School of Agriculture Mediation, I believe. Professor Ogden rather, can correct me when she comes on the screen. So let me welcome to the program, Dr. Ogden.
Thank you.
Good evening.
Thank you. I'm happy to be here.
Very good.
And so the Western Carolina University is the home for the North Carolina and Virginia agriculture mediation programs. They're similar programs located all over the country in over 40 states. And so I'm the director for the one that's located at Western Carolina University. So
excellent. So please, Judith, the floor is yours.
Okay, so do we want to bring up the slides? And again, a little bit of technical difficulties. I won't be able to move the slides, so I'll have to ask that they be moved. And so tonight we're going to talk about some alternatives to avoiding traditional litigations, and the two aspects in particular that I want to talk about are arbitration and mediation. So if we could have the next slide, please. And could we move the slide? Okay, great. So a little bit about what happens in litigation. It's estimated that in the United States, there are 40 million lawsuits filed every year. So that's quite a bit. And on average, it takes 2 to 3 years for a case to go from lawsuit being filed until they actually get to trial. Okay, and so we've temporarily lost these slides. And so I can talk without the slides. It's a little more boring, I think, because I'm just reading off numbers and things. So we're ready to go to the third slide. And it's more about some of the aspects of litigation. And litigation, as we know, can be fairly costly because litigation is very time consuming. And we say it's labor intensive. There's so much work for attorneys and their paralegals and their administrative assistants. Excuse me, starting to cough. It's hard to get an average about how much litigation is going to cost the parties, because attorneys will tell you, well, every case is a little bit different and the costs are different. And so I did find some estimates from 2009 about what the costs of civil litigation would be. And excuse me again, I'm going to cough. But the disparity in prices is tremendous. So in 2009, it was estimated that the cost of litigation for the plaintiff, who's the party who brings the civil lawsuit, can be anywhere from $16,000 to $280,000, and for defendants, it ranged from $5,000 to $300,000. So that doesn't really tell you a whole lot. It's such a big range, but it can be very expensive. And I mentioned a little bit about it. It's time consuming, not only in terms of the preparation needed to go to trial, but even to get a court date, because the courts are oftentimes backed up. And so you may be ready to go to trial, but the case may not get scheduled for, a couple years. Other disadvantages to litigation, well, you might lose. Even if you think you have a really strong case, litigation, especially with a jury trial, can sometimes be unpredictable. And so you're not sure how it's going to turn out. You're not sure you're going to be successful. Litigation is really impersonal, and we say it can burn bridges. So, if you're involved in litigation with another party, they previously might have been your best friend, but once litigation is over, you're not going to have a relationship with them anymore. And it's not just a personal relationship. It could be two businesses who have a desire to work together, and that's going to be ended after litigation. They're never going to be able to work together again. Another disadvantage to litigation is that it is public. And that's the slide we're looking for if it stays up. It's public, and so a lot of things become public information, and maybe some of them are things that you didn't want to be made public. So if we could go to the next slide about the advantages of litigation. Well, some of the advantages are that if you win, you can enforce the judgment. Parties are compelled to comply with the judgments. If you lose, you always have a right to at least one appeal. So if you think the decision is really a mistake, you have an opportunity to try to remedy that. The trial decision coupled with the precedent, with the appeal, can create precedent. So maybe this is an area of law where we need decisions to be made, and there's no existing law on the subject. And so, you're not going to get that from some sort of private method of resolving disputes. Sometimes we need to be in court to change the law. Some people think that litigation works better for complex cases. And sometimes we want a matter to be public. There's a need for public awareness. I oftentimes think of products liability cases. We want people to know that there's a problem with a particular product. If we could go to the next slide. Well, despite the advantages and disadvantages of litigation, the reality is that approximately 95% of cases are settled before they ever go to trial. If we could have the next slide. And this is a result of some of the alternatives that have developed to litigation. One is, of course, negotiation. The parties can just sit down and talk it out and settle. Oftentimes, their attorneys will sit down and negotiate a settlement. Something else that's sometimes used, I think especially in federal court, is they'll conduct pretrial settlement hearings. So there may be a settlement officer who's meeting with the parties, and they try to come up with a settlement rather than having a full-blown trial. Something else that parties sometimes use or try is to hire really an early neutral evaluator. So you bring in a third party, usually somebody who's experienced in litigation, and they investigate the case and the arguments on both sides. And they don't decide the case, but they give you an opinion. So you both sides get a better idea of what might happen if you actually go to trial, and it encourages settlement, basically. And then the last two are mediation and arbitration, and those are the things I'm going to be talking about in the following slides. So if we could have the next slide, and we'll start talking about mediation. And mediation is oftentimes referred to as being assisted negotiation. So the parties are still essentially negotiating, but they, for whatever reason, they couldn't come to a settlement agreement themselves. So now they have brought in a neutral third party who is helping them, who's facilitating, helping them come to a settlement. Usually, mediation is voluntary, and as the slide says, the parties bring in a neutral third party who's called a mediator to help them. Now, the mediator is not a judge, and the mediator doesn't decide who is right or wrong. The mediator is really just helping the parties to come up with a settlement. Next slide. So these are three basic types of mediation, and mediators sometimes use the different terminology, or they use terms interchangeably, and sometimes these three basic types are broken down into like subcategories. But most mediators say that they use a facilitative type of mediation, and if you're a facilitative mediator, again, you're not telling parties what to do, what they should do. You're certainly not deciding the case. You're just helping them explore, what their interests are, what their needs are, what they might be willing to accept. And so most mediators will say that they use a facilitative type of mediation, especially with cases where there's pending litigation. We sometimes call this a problem-solving type of mediation. There's a problem and we need to solve it. We need to come to a resolution. Some mediators use an evaluative form of mediation. And if you have an evaluative style, you tend to give the parties your opinion more often. You make recommendations. Most mediators don't use this type of mediation, but sometimes that's what the parties want. And sometimes that's what their attorneys want. They want someone who will help the parties realize, to be more realistic. We sometimes say that the mediator is an angel of reality, because parties watch TV and they see people win multi-million-dollar lawsuits, and they think that's the way it's going to be for them. And sometimes they need some third party to tell them that that probably isn't realistic. And a third style is called transformational mediation, and it's a little bit different from problem solving in the sense that it's less about solving a problem and coming to a resolution in terms of how much should one party pay in terms of damages. It's more about transforming the relationship between the parties. And so the style and the techniques used are usually a little bit different from facilitative. And so this is a style that's oftentimes used with family disputes, or it could be workplace disputes when you're really just trying to get two parties who have to work together and just do not get along. You're helping them to improve their relationship, to understand how to talk to each other and how to work with each other. Next slide, please. So why would you want to mediate? So there are many reasons for using mediation, if at all possible. The decisions are more economical. The mediation really is less expensive than going to litigation, and there's a rapid settlement. They're usually much faster, occur much earlier in the process. You can come up with a mutually satisfactory outcome. So unlike a lawsuit, let's say we have a plaintiff who is suing a defendant for a breach of contract. And they have a civil trial, there's a jury. The jury's going to decide, did the defendant, in fact, breach the contract? And if they did, how much money should the plaintiff be awarded in terms of damages? And that's it. That's all they can do. Who wins and are there damages and how much? That's their whole job. But with mediation, I like to tell my students that the parties can do anything or agree to anything that isn't illegal. So you can be creative and inventive. And so if you have two parties and they have a contract that isn't working, but they really would like to continue working together, and there are advantages to perhaps them working together, well, the result of the mediation is they can rewrite the contract. They can do anything they want as long as they're both in agreement and it isn't illegal. So you have outcomes that you'd never see in litigation. And consequently, we believe there's a high rate of compliance because the parties had add input to what the outcome is. And another way of saying all this, I guess, is that you come up with comprehensive and customized agreements. You come to a solution that is perfect for your situation. It's customized, and you have a greater degree of control and predictability. Parties oftentimes feel empowered because instead of it being the judge or a jury of people they don't know telling them what they must do or how much money they owe, they're involved in the final decision making. It can preserve an ongoing relationship, or even if there's a termination, it's much more amicable. It's not adversarial the way that litigation is. Workable and implementable decisions, of course, are a result of this process. And agreements oftentimes, as I've suggested, are better than simple compromise or a win-lose. They can be very unique and designed to address your particular situation. Next slide, please. So these would be typical steps in the mediation process. This is the day of the mediation. So prior to the day of the mediation, there may have been some pre-mediation contact with the mediators. It just depends on the mediator. Different people do different things. Some mediators like to know as little as possible about the case before the day of mediation, and others like to interview both sides and get more background information. But the day of the mediation, everyone's usually starts out in the same room. The mediator makes some opening statements in which they explain what mediation is and how the process is going to take place, the agenda, logistics, those types of things. And usually then each side gets a chance to make their opening statements, which is, a summary of their perspective of the situation, how they see the situation. Sometimes then the parties will exchange information and discussion with each other, and they may actually be negotiating. And I've seen mediations where this is the first time the parties have even talked to each other. And so there's sometimes an exchange that goes on right in the mediation for the first time. The next thing that can happen, and not all mediators do this, but many mediators like to caucus. And by that we mean the mediator meets separately with both sides. And so first they might meet with the plaintiff and the plaintiff's attorney, if there is one, out of the hearing of the defendant and the defendant's attorney. Anything that's said in caucus is confidential, and the mediator will not repeat it to the other side unless the party gives their permission. And as you get to the end of the mediation, as they're making offers, they'll tell you, tell the other side, I'm willing to accept this. But it gives the mediator a chance sometimes to find out what's really going on and what the underlying issues are. Even though the mediator may not repeat this to the other side, the mediator understands the situation better. Now, some mediators never caucus, and a lot of times with transformational mediation, there's no caucus, because what you're trying to do is get the parties to talk to each other, not just resolve a problem. But caucus or not, hopefully at some point there's closure and an agreement. And the next slide, please. So how many cases are settled in mediation? Well, again, it depends on who you ask, and it depends on a lot of things. But I've seen estimates of 60 to 85% of cases that use mediation will settle. 60, I think, is a little low. Most situations I've seen, it's probably closer to 80 to 85% of the cases settle in mediation. And I think that's a good objective for the mediator, to have 80 to 85% of their cases settle in mediation. I have known mediators who say 95, 98% of my cases of my mediation settle. That makes me a little uncomfortable to have that high of a number. I'm afraid that they're putting a lot of pressure on the parties. Sometimes in a mediation, the parties don't have attorneys, and it's just two individuals with whom you're working, and there could be a concern with some some mediators would be more concerned with getting their settlement rate up than doing what's best for the parties. Next slide, please. So we're going to say a few things about arbitration, and after we discuss arbitration, we'll be talking about court-connected mediation and arbitration and international mediation and arbitration. So arbitration is a little bit different. You're again going to use a neutral third party who has no interest in the outcome of the case, but they're not helping the parties to settle. They're actually going to make a decision in the case. So arbitration is a private determination of a dispute by an independent third party. And sometimes you have one arbitrator, or you could have more than one. Three isn't that uncommon. I've even had seen situations where there are 5 arbitrators, but I think 5 is a lot to try to work with and try to get an agreement among the arbitrators. So sometimes we say where there's more than one, though, there's a tribunal, and it's probably an odd number of arbitrators. Next slide. So in some ways, arbitration is really similar to going to court, but there are important differences. The arbitrator or the panel have been hired by the parties. So, if you go to trial, you're just assigned a trial judge. You haven't selected them, and you don't really pay them out of your pocket. So the decision in arbitration is called an award, and arbitrators usually consider applicable law, or it might be a contract interpretation. So they're looking at the language in the contract, but unlike mediation, their job is limited. They can't come up with some off-the-wall resolution like, hey, let's rewrite the contract. If it's contract dispute, it's much more like a trial. They interpret the language of the contract, and they determine if the defendant has breached the contract, and if the defendant has, what are the damages? They can't come up with really very creative resolutions. So arbitration is essentially a private trial, but it's been used since Greek and Roman times. So it's been used for a long time. And can we have the next slide, please? So it's similar. It's to some extent, it's a private trial, but there's important differences. The parties create the contract that governs the process. So the parties get to pick an arbitrator. And this means the arbitrator could be an attorney, but wouldn't have to be. So sometimes you want an arbitrator who has, special expertise in a particular area. So a good example would be labor arbitration. A lot of labor arbitrators have a background in labor, and by that I mean union management disputes and collective bargaining issues, but they're not necessarily attorneys. They could be, but the experience with the subject matter is probably more important than having a law degree. The parties can choose to use more relaxed rules of evidence. So in a trial, you have rather rigid rules of evidence especially where there's a jury, because the jurors aren't professionals in the subject of litigation, and so you want to keep the trial as fair as possible and something that the jurors can understand. But if you don't have a jury and you're using an arbitrator who's arbitrated many cases before, you can be a little more relaxed about the rules of evidence. And if something gets admitted that really shouldn't have been admitted at the hearing, an experienced arbitrator will know to just disregard it without it having to be removed from the transcript. We like to believe that parties get a quicker resolution and a less expensive resolution with arbitration. Sometimes that's true. It's not always true. Arbitration, especially of a complex case, can take a long time, can take a long time in preparation, and can be very expensive. Next slide, please. With arbitration, the award usually cannot be appealed. And this is because most often when parties agree to use arbitration, we say that they agree to use binding arbitration, and that means they'll accept the result whether they like it or not, and they won't appeal. So, this is sort of good news, bad news. If the award is one that you like, then you're happy to accept it, and you're glad that the other side can't appeal. But if there's a bad decision from either perspective, somebody or sometimes both parties may wish that they could appeal. Moreover, because arbitration is a contractual agreement between disputing parties on how to resolve a dispute, they can determine what rules and procedures are to be used in the arbitration process. So oftentimes what happens is, arbitration comes about as a result of a clause in a contract between two parties where they agree if a dispute arises, we're going to use binding arbitration to resolve it. And so the parties can determine, how are we going to select an arbitrator, and is it going to be binding or not? Are we going to keep a recording of it or a record of it? They can pretty much fashion it however they like. Next slide, please. So this would be a rather typical arbitration hearing procedure. At some point, the parties have probably agreed to use arbitration. And there's a pre-hearing conference where they would, usually most often probably with the arbitrator and the attorneys, to do things like, schedule dates for the hearing and to exchange documents. Sometimes they might want to clarify some issues because as they've gotten farther into the case, they realize that there's some matters that really aren't in dispute. What are the issues we really have to have decided at the arbitration hearing? There is some discovery, and I'm not sure how familiar everyone is with discovery, but in a civil trial, there's very extensive discovery before trial. And this means that both sides get to request and receive from the other side a lot of their evidence. So if there's documentary evidence, they will take a deposition of the other side's witnesses. So they'll question the other side's witnesses under oath, and a recording will be made. If there's personal injury, they might request that the defendant might request that the plaintiff be examined by their doctors. So, and the point of all this is, unlike, again, what you might see in television or movies, there's not a lot of surprise when you get to trial because you've already seen a lot of the other side's case. And also, it leads to settlement more often because you both know your case and their case. And so you might decide we might as well just settle because, we're not very positive about the outcome of trial. Well, after that long explanation, in arbitration, there is some discovery, but it's much more brief. Documents will probably be exchanged. In a lot of arbitrations I've done, there are no depositions. You don't interview the other side's witness ahead of time. Then there comes the day of the hearing, and then at some point, the arbitration panel will give you an award. It's probably not the day of the hearing. It's at least 30 days out, probably, before you get a decision. May we have the next slide, please? Now, both mediation and arbitration can be selected privately by the parties. So the parties, if they have a dispute, regardless of what their contract says, even if they didn't include a contract clause, when they have a dispute, they can say, well, why don't we try mediation? Or they can say, why don't we try arbitration? So they can always decide on their own that this is a viable alternative to litigation. But sometimes a mediation and arbitration are court-connected or court-annexed. And could we have the next slide, please? So if you look at court-connected mediation, oftentimes judges will order civil cases to go to mediation before the trial, hoping that it'll settle before going to trial. It's estimated that in Florida, nearly every single civil case is sent to mediation before they have a trial. That's just become commonplace. But the mediators here are ones who are, we say they're court certified. So the courts have a list of mediators. You have to use one of them. Court-connected mediations are often limited in the time allowed. So they will meet for a limited amount of time. The mediation can't go on for days and weeks or whatever. And so sometimes it makes it less likely that the case will settle in mediation. But, and I really believe that just going through a mediation, even if you don't settle, that there are benefits to it. It helps to narrow the issues and make decisions about discovery. Could we have the next slide, please? Mediation also opens up communication, and it becomes more likely that the parties will settle quickly and fairly following the mediation. Now, we have no statistics on this, but I rather suspect that even if a mediation isn't successful at the time, that oftentimes, whether there's a court case pending or not, that the parties settle on their own because they've learned to talk to each other, and they've learned so much more about each other and the case, and they can talk to each other. If parties don't settle, though, they can still go to trial. And one of the things that makes mediation so appealable is nothing that's said in mediation is admissible at trial. So you could have a mediation where I admit that, yes, I ran the stop sign and ran into your car. We don't settle. We can still, if we go to trial, you can't bring that in that I admitted it. It's like it never, like it never took place. And let's see, I don't know if you can see me there. I'm back. And the reason for this is they want to encourage people to be, forthcoming in the mediation. If people are guarded in what they say, the case probably won't settle. If you can't be honest and open, the case probably won't settle. You might as well just go to trial. Next slide, please. If the mediation does result in a settlement or agreement, the parties sign releases, payments made if appropriate, and the lawyers let the judge know that they send a dismissal order and the judge signs. And at that point, the legal case has been resolved. Next slide, please. Now, in these court-connected mediations where you have to use one of the court-certified mediators, in order to be a court-certified mediator, you have to meet certain qualifications. For some cases, in some states, you might have to have a law degree. In other states, you might just have to have a bachelor's degree, but maybe a certain number of years of experience in whatever your field is. And on top of that, you probably have to go through training, and that can vary from state, anywhere from 20 to 40 hours of mediation training. Now, if it's a private mediation and it's not court connected, you and your opponent just decide, let's try mediation. You can hire anybody you want to do the mediation. It doesn't matter what their background is, what their training is. You could hire my mother. Whoever you want, whoever you feel comfortable working with, you can hire in a private mediation. So it's the court-connected mediation where there are requirements for the mediators. Next slide, please. And could we have the next slide on arbitration? In some states, a judge will send parties to arbitration before a trial. And how often this is used really depends on the state in which you're located. I'm located in Georgia, and although there are state laws allowing for court-connected arbitration, someone told me that there's only been like 2 arbitrations since the statute was passed. So Georgia doesn't use a lot of court-connected arbitration, but that's not necessarily true in other states. A lot of states have some states have a requirement that if you have a civil case that involves a certain amount of money, like $50,000, you have to go to arbitration before you can have a trial. because $50,000 is considered a relatively small amount of money to litigate. Now, the arbitration award in this situation is usually not binding, and you can appeal. So the court in some states may force you to go through an arbitration hearing, but you don't have to accept the award from the arbitrator. Probably most parties do, because it's probably a pretty good indication of what's going to happen at trial, but you don't have to. And you can say, no, I want to have a trial de novo. And novo means new. So what would happen is, if you don't accept the arbitration award and you ask for a trial, you get a trial. It's not an appeal. It's, you start from scratch. The whole trial goes through the same process as it normally would if you'd never had an arbitration hearing. Next slide, please. So for these court annexed arbitration, usually the arbitrators are attorneys. And again, if it's a private arbitration, you can select anyone you want as your arbitrator. Again, you could select my mother, you wouldn't want to, but you could select anyone who you think understands and can render a fair decision. Arbitrators' experience in certain areas relevant to the case are oftentimes chosen. Here, a good example is in the construction field. So I would never be selected as an arbitrator in a construction case because I wouldn't understand the technicalities of it. So people who do have a background in construction who are arbitrators, that's really a specialty, and that's who you would look for. Next slide, please. Both mediation and arbitration are also used internationally. And the next slide, please. And so an example would be the European Union issued a directive back in 2008 requiring all of its member states to implement cross-border mediation laws. And these are some of the characteristics that those programs have to have. And they have to train the mediators, and the courts will refer parties to mediation. If there is a settlement in mediation, that the courts are required to enforce it. They can't just ignore it and do a trial instead. Again, the thing that makes mediation so appealing in all situations is it's confidential, and so that needs to be included, and they are to notify and inform the public that this is available. Next slide, please. Now, when it comes to international commercial disputes, arbitration has been used really for some time, and it's much more popular, I think, than litigating, because oftentimes, if you have businesses, say, who engage in a commercial dispute, they really don't want to use the court system of one country or another. They'd probably rather use arbitrators. And it requires the agreement of the parties, which is usually given in an arbitration clause, which is inserted into the contract or business agreement. So it's really common for businesses in international commerce, as part of their contract, to have an arbitration clause, and and it usually says that the arbitration is binding. Next slide, please. And I guess, as I've suggested, is parties may distrust a foreign legal system. With arbitration, the process is somewhat similar, and the parties agree to what rules we're going to use. So they have something to say about the whole process. You get into litigation in another country, you may not trust the system, but the process could be completely different, and so you may not be comfortable with that. And litigation in a foreign court can be time-consuming, complicated, expensive. You've got to get attorneys from that other country as part of your team. And another problem is a decision rendered in a foreign court is potentially unenforceable. So let's say you have a company in the United States and it does business with a company from Russia, and a dispute arises. And so the U.S. company sues the Russian company in U.S. courts and wins. And so now they want to enforce that judgment from the court, and they have to take it to Russia because that's where the defendant's assets are. So they go into Russian courts to try to enforce that judgment. And the Russian courts say, well, we don't recognize that judgment. We don't recognize decisions from United States courts. We don't approve of the way this case was handled. They could give whatever reason they want. But one of the reasons that arbitration has become popular is court decisions were oftentimes unenforceable in another country. Next slide, please. But arbitration awards have a degree of international recognition, and that's because there have been so many conventions that many countries have signed on to, in which they agree to enforce these arbitration decisions. Now, a lot of these conventions, they don't require the parties to use arbitration, but if they use arbitration, the countries have agreed that their courts will recognize and enforce the arbitration award. And one of the best known conventions of this type is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It was written, in 1958. More than 140 countries have agreed to abide by it. It's also known as the New York Convention. And so you might have heard of, you might hear of the New York Convention. It's a simpler name. And so, so countries who have signed on to this convention have agreed that they will enforce arbitration awards. Next slide, please. So many international agreements, treaties, and conventions facilitate the use of arbitration as a method for resolving disputes, and some just address the enforcement of the awards. But commercial arbitration is extremely popular and probably safer than litigation in many cases. And the last slide, then, this is really the end of my PowerPoint presentation, and now maybe we have some questions.
Indeed, I see that we do have a few questions. First of all, thank you very much for that. That was extremely interesting, and I apologize to you, Judith, for our technical problems, which made the beginning a little hiccup strewn, but just the same, very informative. Thank you so much for that. And so we could go first to our questions from the audience, which show that they're much better informed on the topic than I am, because I don't entirely. Gulnar, for instance, asks, "Dear Professor, I have a question regarding our current situation. Which one is more convenient during the quarantine regime? Ad hoc arbitration or institutional arbitration, and why? Thank you." Does that...
Well, ad hoc means that you just, the parties just decide we'll use arbitration, and institutional would be court connected. Is that what they mean by institutional? Or sometimes pardon me? Sometimes some government agencies will, and this depends on the country, so I'm not entirely sure what's happening in Azerbaijan. I think it all comes down to how you're going to conduct the arbitration during a pandemic. So it's become much more common to do remote or do virtual arbitration, where you use like Zoom or some sort of platform, and there are many out there. And so the parties, their attorneys, the arbitrators are all different locations, and they're doing kind of a Zoom method. So I would say I don't know if there's a difference between doing it ad hoc or institutional, other than maybe ad hoc is more flexible. And in order to do a virtual arbitration, you have to be a lot more flexible than was true in the past. And again, I don't know what's going on in Azerbaijan, but I know, and we sort of talked about this a little bit, some government agencies are reluctant to use certain platforms, so that may complicate the situation. We've had mediations with government agencies, and they absolutely will not use any platform at all. And so we just keep either postponing the mediations or we do it on the phone, which, I'd rather do a virtual one where you have a camera than do it on the phone. But so I don't know what the answer is, but I think it depends a lot on what institution you're working with and how flexible they are and how receptive they are to, virtual arbitration or mediation or whatever. The other thing too is I'm wondering if, we know that we're supposed to be experiencing social distancing. So it seems to me that with certainly with mediation, but even with arbitration, you still could do it in the same room, as long as you might have to wear a mask. Somebody has to be cleaning the surfaces all the time. And as long as they're all 6 foot away, that's probably less dangerous than going to the grocery store, So I'm not sure that they all have to be virtual, but in some arenas, there's a real reluctance to do anything right now: arbitration, mediation, live, virtual, anything. So I hope that answered the question.
Yeah, no, I think comprehensively. The second question actually seems to be more of an observation from Oktay, who points out that this January, the Ministry of Justice here in Azerbaijan convened a training session for mediation trainers to help local mediation techniques in that field, which actually emphasizes one of the reasons we chose this topic, because it is going to be appearing in Azerbaijan. It's going to be a commonly used form of resolving investment disputes. So we're really fortunate to have you talking a little bit about it, and we hope that the law students who are watching this evening have a chance to really bone up on their arbitration mediation, because it is going to be replacing litigation here in Azerbaijan as it has done elsewhere in the world. So we're delighted to take more questions in the meantime. So we'll keep an eye peeled on the comment bar. But in the meantime, I had just a few questions. I mean, when we talk about you pointed out that arbitration is increasingly being used to resolve disputes between parties from different countries, international arbitration. Who is the core of arbiters or arbitrators, I guess we would say, and where are they based? Does the arbitrator come to Azerbaijan to resolve a dispute, or do all the parties get on a plane and hop off to Geneva?
It's really complicated. It's much more complicated than that. The parties can decide how they're going to select an arbitrator, and so there are different organizations of international arbitrators. And so the one that, of course, I'm most familiar with is the American Arbitration Association. And within the American Arbitration Association, they have groups of arbitrators and mediators in different specialties. And one is international. And so you and the other party might decide, okay, let's ask the American Arbitration Association to send us a list of panelists, and we will select from them. And usually the arbitration is held in a third location, not where the two parties are from. So a lot of international arbitration is conducted in Paris, in London, in the United States, of course, New York and Houston, and Atlanta, where I live, has been trying for the last maybe about 5 years. They created a center at the Georgia State Law School for the sole purpose of doing international arbitration, and they keep trying to sell it to the world, because if you know anything about Atlanta, it has the busiest airport in the world. It's very easy to get to, and but the cost of living and other things is actually much less expensive than many other cities. So two parties just agree on this. There are people who specialize in international commercial arbitration, and they decide, where we're going to get the arbitrator from, and are we going to have one arbitrator or a panel, and what city do we want to do this in, and what rules are we going to use? And it can get fairly complicated. And some of these are big cases, big complex cases with a lot involved.
Interesting. You'd said earlier in your session that you viewed with some suspicion mediators who have a super high settlement rate, because you suspected they'd put pressure on the parties. I thought one of the reasons we put competing parties or diverging parties in front of a mediator was to make them iron things out and get this done and dusted. Why do we care if some pressure has been put on them? Would that lead to a less positive outcome? Is somebody going to go away with
a bad result? A bad result. That's the concern. Not that the result is great. It's that, and I have seen a few mediators who they seems like their primary concern is to have a really high success rate, and so they get people, especially people who aren't represented by attorneys, who would agree to a settlement that isn't a good idea. Wouldn't have been in their best interest. They shouldn't have taken it, and if they had an attorney, they probably wouldn't have taken it. But the mediator's not there to represent either side, and so it's always a difficult situation for the mediator when you see somebody making a really bad mistake. You're not supposed to take sides, and you're not their attorney, and some mediators aren't attorneys, but you also don't have to pressure the parties to accept some, so in private caucus, persuade them, well, I don't think you can do any better if you go to trial, and, just some of these types of things. The concern is not that, if you don't do that and you have a high settlement rate, that would be great, but just statistically, it's unusual for somebody to have a 98% success rate. Some disputes just do not lend themselves to settlement. You need a third party to decide the case, they just shouldn't settle.
Right.
The court.
One thing you read about periodically is, particularly in the United States, employment disputes are increasingly being resolved through mandatory arbitration. Yes. I believe, which has been shown to be possibly more damaging to either the employees or, in the case, I guess, of commercial disputes, consumers. Why is there such a thing as mandatory arbitration? Is it written into the initial contract when the employee
goes
on with the company?
Yeah. Well, let me do the commercial first, because you have mandatory arbitration if you have a cell phone, and I'm guessing you do. When you signed up for that, your contract had a mandatory arbitration agreement. If you have cable TV, if you have any credit cards, all those contracts have mandatory arbitration clauses in them. So if a dispute arises, you've agreed to go through arbitration. You can't go into the courts, and it's usually binding arbitration, so you normally can't appeal the decision. And the thinking is, well, of course you read your contract before you signed it or before you took that cell phone, and if you didn't like the clause, you didn't have to take the phone. Realistically, when you're dealing with the average person, this is certainly not true, but the courts have upheld these clauses for at least the last 30 years. People have been litigating whether or not these clauses should be enforceable and whether or not they're fair, and the courts have upheld them. I always like to say the courts love arbitration because it takes cases out of the courts, and the U.S. Supreme Court loves arbitration clauses, and this is true over the last 30 years. They always uphold an arbitration clause. And in employment situations, everybody doesn't have an employment contract if you do, it probably has an arbitration clause, but this is just part of the employer's policy. And so when they hand you the handbook that nobody's ever going to read because it's so long, well, I guess they don't hand them to you anymore. They're all online, and so you have to read them online. There's very likely a mandatory arbitration clause in there, and if you don't like that, you shouldn't have taken the job. That's the mentality, and so courts enforce it, even though we all know that nobody reads that stuff. A lot of people don't understand the stuff. There certainly have been cases where the mandatory arbitration clause in employment has been set aside, but those are kind of extreme situations. For the most part, they have been recognized. And of course, if you're a civil servant, there's probably state laws saying that you have to use arbitration. So.
Distortion on the line, by the way. Can you hear me okay? I'm getting feedback. Okay, great then. So my next question was, I mean, why are the findings typically pro employer, pro vending company? What is the formula typically that an arbitrator rather would use to determine damages? Why has it historically favored the defendant? Does that make sense? Question?
Yeah, no, you mean the employee or the consumer?
But I understand that typically it favors the employer or the vendor of the good. Who is the defendant?
Yeah.
And it favors the defendant, exactly. So that seems to be the case. What is the process of assessing damages?
Well, that's hard to answer. It depends on the case.
Right. Okay. Do you have any reason why it would be historically slanted towards one party? It sounds like is the fix in.
I don't know if that's. I hate to say that that's always the case. It makes a big difference in terms of the arbitration process. So employers, coupled with these mandatory arbitration agreements, is at least initially, employers would put other limitations on the case. So the case could only go for 1 day, and there's no discovery. And just, they'd add other things that would stack the deck. And so a lot of those cases, if the employee is willing to take the case farther, courts have thrown those decisions out because it's just so unfair. It's like an unconscionable contract agreement. I think sometimes with an employment arbitration, a lot of times employees go in without an attorney, and so whether the employer has an attorney or not, they're more experienced. It's. I know people watch a lot of trials and things on TV, but I think for the average person to go in and represent themselves in a hearing or a trial is difficult. You're just not as experienced. What's admissible, what isn't, what's relevant, what am I allowed to do, what am I not allowed to do, can I call witnesses? You don't know what to expect. And so, I've seen arbitration hearings where people go in unrepresented, and I see that in mediation too, in employment-related mediation, where the employer has an attorney and the again, I mentioned that before, and the employee doesn't. If I'm being really cynical, and I wouldn't say this always happens, but it's a concern. Is and one of the situations where the courts have thrown out some arbitration clauses is where you as an employee are probably only going to be involved in one employment-related arbitration case, but your employer, if they're large enough, could be involved in a lot, and they know the arbitrators, and the arbitrators know that if I keep winning against the employer, nobody is going to hire me. The employee doesn't know who I am, and so one of the situations where the courts have thrown out these clauses is where the pool of arbitrators was so small that the employer knew them all. Now, if you use the American Arbitration Association, they have thousands of arbitrators, so that's probably not a problem. So a well-written arbitration clause would say, and we're going to pick our arbitrators from the American Arbitration Association. That's probably a safer bet. But I have seen some cases where there's just this little pool of arbitrators, and of course, if they kept rolling against the employer, they weren't going to get any work. And I can't say, I don't know who any of these people are, so I can't say they're really doing it. But the court said it has the appearance of not being fair, and you just can't set up a program like that. I know in some of the consumer cases, one of the problems is that the amount of money involved isn't enough for, having a dispute with, my cell phone company. It's not worth it to me to hire an attorney because the amount of damages is not going to, if I win, it's not enough money involved.
Right.
And so they attempted to bring a class action suit so that all these little, cases could all be lumped together, and then it was worth hiring an attorney. And the Supreme Court struck that down and said, no, it's not an appropriate situation for a class action suit. Individually, you got to handle this. So if you.
Oh, that's interesting.
I know. That's also
unexpected. Well, we really do try to limit the caseload for the court system. I guess they really are trying to push things into the realm of arbitration mediation, which does make sense. One last question. I see where time is seriously nigh, but other than the speed of the process, what are the differences between litigation and arbitration? Is the process different? One of a question I fielded actually on my mobile telephone is, in cases where expert witnesses are needed, does arbitration allow for the submission of written reports? Is there a mechanism to replace cross-examination when witnesses do not testify? Which goes again to the process. What are the differences in the process?
It all depends on, now you could have a situation where the parties agree. Maybe one of your witnesses is in poor health, and the parties themselves can agree. When we'll have a written deposition or we'll use something else. The party can always agree to run it however they want. And beyond that, it's up to the arbitrator. You at some point, if you can't agree, you put everything in the hands of the arbitrator, the panel of arbitrators. And also sometimes when you're doing an arbitration, the parties agree. I do arbitrations for for FINRA, for the financial industry, New York Stock Exchange, and that sort of thing. And they have their own written procedure. So if a question like that would come up, the arbitrators would refer to, what does FINRA's, the financial industry, they've written rules on this. We would just follow their rules. But, there's no standard that everybody must follow in arbitration, and things come up that have never come up before. And usually you leave it in the hands of the arbitrator to decide how to handle it. And the arbitrator always wants the process to be open and fair. And so when they make a decision about, will we let a deposition in instead of a witness, you have to ask, does that seem fair? Is there a reason we have to have this person here? And if they can't come, these sorts of things. And what were some of the other? There were other things, not only witnesses who couldn't come, but who makes decisions about what else?
It was a function of would they accept written testimony as opposed to cross-examination of an in-person expert.
Yeah, that depends, but they have to. You could submit a report, but written testimony, you'd probably need some sort of deposition, because a written statement isn't the same thing as cross-examination. So somehow it could be written, but somehow.
Right. Because a written statement wouldn't allow for cross-examination, right. Would written expert testimony suffice in arbitration, I think was the question.
Yeah, I think it just depends. I think it just depends. And yeah, some expert testimony, there may be no reason to cross-examine. You know, the person's an expert, and you know, you could insist that they come in to make things more expensive and difficult, but you would just be giving the other side a hard time. You know, you're just trying to. Some attorneys like to make things difficult for the other side and as expensive as possible. But if you know that the person's an expert and you trust and you know the report is accurate and there's no real reason to cross-examine, you might accept it. It might, you know, there's always enough to argue over.
Questioning the validity of the statement. I mean, there could be follow-on questions that the report begged. Yes.
I'm sorry.
Does that make sense?
You kind of went out a little bit.
Yeah, I have a feeling my sound quality is fading. But it was, I mean, in addition to questioning the validity of the statement, the cross-examination could allow for probing into different areas.
And you might be able to use written questions. They might let the other side submit written questions if there's a reason to not have the person come. The parties can agree to whatever they feel comfortable with, and ultimately, if they can't agree, the arbitrator has to decide what they think is fair and necessary. You know, okay. If it's an expert on a minor point, you know, next.
Well, very good. Well, that is absolutely all the time we have. We've gone well over, so we thank you for your time, Professor Ogden. You've been wonderful. The 3 sessions, first the trial by jury, then the exploration of search and seizure, and today mediation and arbitration have been highly educational, highly interesting. And I would say to the people watching and the people who come to our Facebook page that these will stay up on the Baku American Center and Embassy Facebook page. So please come back and revisit. And this session in particular is going to have increasing relevance for the Azerbaijani context. So really take advantage of this opportunity to learn a little bit more about an increasingly important part of law, of corporate law. But for now, Judith, we would just thank you so much again for your generosity of time. We were sorry that the coronavirus hastened your departure from Azerbaijan. We again.
I was hoping to volunteer to do mediation training, but suddenly I was out of the country. And I was talking to the law students about it, but.
And let's hope that the fates allow you an opportunity to come back. We would absolutely love to welcome you back. We'll be talking with the Fulbright committee about how that might work. But for now, best of luck down in Atlanta, and thank you so much again, and we'll stay in touch. And
I've enjoyed this very much. I've enjoyed it very much. Thank you.
Thank you very much, everybody, and good night.